take a look at the Constitution of the United States. Now, again, you're going to find these handouts, the Constitution as well as the Constitution as a bundle of compromises. You have copies of those on the homepage, the campus homepage for this course. Okay. What we're going to do is we're going to just take a look at, kind of go through the Constitution and take a look at some of the major highlights, and again discuss other aspects of this plan of government. Okay, so the most important articles of the Constitution are Article 1, Article 2, and Article 3. Those first three articles establish the three branches of government. Article 1 establishes the legislative branch. Article 2 establishes the executive branch, the presidency. And then Article 3 establishes the judicial branch. Okay? So, with that said, let's just take a look at Article 1. In Article 1, Section 2, Clause 2, it specifies the requirements to become a member of the House of Representatives. So it says, no person shall be a representative who shall not have attained the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Okay? So to be a member of the House of Representatives, you must be at least 25 years of age. You must be a citizen for at least 7 years. So the idea then is that there are two categories of citizen. You have natural-born citizens who are born here. And then you have naturalized citizens who are born in some other country, who then move to the United States and they become a citizen. So if you're 25 years of age and you're a natural-born citizen, then you've been a citizen of the United States for at least 25 years. But so this requirement of 7 years as a citizen is mainly for naturalized citizens. That for naturalized citizens, if you are 25 years of age, then you also have to have been a citizen for at least 7 years. And then you qualify to become a member of the House of Representatives as well. Now, in Clause 3, this establishes representation. And this is the part that includes the 3/5 compromise. So you see where it says in Clause 3, representatives and direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound to service for a term of years, excluding Indians not taxed, 3/5 of all other persons. And so, again, the idea of the free persons, that's any person who is not an enslaved person. Those who are bound to service for a term of years are indentured servants. Okay? So indentured servants would generally be bound to service, required to remain a servant for 4 years or 7 years. So if you were, again, bound to service, you were an indentured servant, and it excludes Indians not taxed. There were quite a few Indians who were living alongside Anglo-American settlers, living in the same communities, going to the same churches, farming the same fields. And those Indians who were living in these Anglo-American communities were Indians who were taxed, just like everybody else. And so they would be included as part of the population. Now, for those Indians who remained living on their tribal lands, well, then those were the Indians not taxed. So they were not included as part of the overall population. And then 3/5 of all other persons. When a vacancy happens in the representation of any state, the executive authority, the governor of that state, shall issue writs of elections to fill such vacancies. In other words, if a member of the House of Representatives resigns from office before their term is over, if they die, leaving a vacancy, then the governor will schedule a special election to replace that member of the House. Now, beginning in Section 3, it starts to talk about the Senate. And again, for the Senate, they serve 6 years. Members of the House serve only 2. And to be a senator, no person shall be a senator who has not attained the age of 30 years, and they must have been a citizen for 9 years when elected, and they must be an inhabitant of that state for which he shall be chosen. So today you hear some controversies. For example, there is a person who is running for a Senate seat, I believe, in Pennsylvania, who lives in Connecticut. They need to understand that that is a violation of the Constitution. That person should not have been nominated. And I believe there is another senatorial candidate for Michigan who is living in California. Okay? So, again, these are some of the problems that develop when we lose sight of what our Constitution actually says. And I'm willing to bet this may be the very first time many of you, if not all of you, have been required to look at the Constitution this closely. And that is a shame. That is a national embarrassment. That it's very likely that all of you are at least 18 years or older. You're eligible to vote. And yet, you haven't been asked. You haven't been required to look at the Constitution, at what it actually says. Let's talk about something else here. Let's see if we can. Okay, let's look at this part, because this is something else that is becoming an issue in the current situation we're facing. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment. So it is entirely up to the House of Representatives to determine if any federal officer should be impeached. And that could include the President of the United States. It could include any member of the federal judiciary. Okay? It could include any member of the cabinet, like the Secretary of Defense, the Secretary of the Treasury. Okay? That's the decision to impeach any federal official is entirely up to the House of Representatives and no one else. Okay? Now, if the House votes to impeach, then the Senate shall have the sole power to try all impeachments. And then when sitting for that purpose, they shall be on oath or affirmation, when the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of two-thirds of the members present. Okay? So, the idea then is, if the House impeaches, there must be a trial in the Senate. And if the decision is made by the House to impeach the President, the Chief Justice of the Supreme Court will preside over that impeachment, over that trial in the Senate. But then no person shall be convicted without a concurrence of two-thirds of the members present. So a two-thirds vote is required of those present to convict. And then the judgment in cases of impeachment shall not extend further than to the removal from office and disqualification to hold and enjoy any office of honor or trust or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Okay? So the idea then is we like to tell ourselves that presidents are not above the law. But in a kind of real way, when they are actually president of the United States, they kind of are above the law. You kind of have, and I know this is kind of tough, you have the law, you have the president law. But that's what the impeachment process is about. If the president has been found to have done something so egregious that they can no longer legitimately serve as president of the United States, well, then the House can impeach them. And once they are impeached, they go to trial in the Senate. Now, if the Senate convicts them, as Clause 7 says, the judgment in cases of impeachment shall extend no further than removal from office. So if the Senate convicts the impeached president, then that person is no longer president. They're just a private citizen. And then as a private citizen, you have law, private citizen. And then, as the Constitution says, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Now, this part of the Constitution has been turned completely on its head by a recent Supreme Court decision that has somehow determined that the president has immunity. That, in other words, the president can do things that are in violation of the law. As long as they do those things, cloaked as an official action of the presidency, then according to a new interpretation of this part of the Constitution by the Supreme Court, the president cannot be indicted. The former president, I should say, cannot be indicted, will not have to face trial or judgment or punishment. And again, this is the thing that I will be reminding you of and repeating throughout this presentation. The Constitution is only as good as we are. If we do not hold up the Constitution as it is meant to be held up, then the Constitution is not very good. Because we're not being good. And the problem is, because so many Americans are ignorant of the details, they don't understand. They may not even care. And this is how we turn into a dictatorship. The Constitution is what protects us. Okay? And in order then to know how it protects us, we have to know what it says. And we have to be able to recognize when the Supreme Court is going against the Constitution. There's really nothing hard to understand. In all honesty, I do not see a single SAT word in that Clause 7. Judgment in cases of impeachment shall not extend further than to removal of office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. So again, if a president is impeached, then they can no longer serve in any office whatsoever in the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Now, to be clear, this whole issue of presidential immunity, the president is immune in certain cases. So, for example, if Congress declares war, for example, and soldiers go fight in that war, and soldiers are killed, and the President of the United States is the commander-in-chief, well, the president cannot be sued for wrongful death because somebody's son was killed in that war. So in that case, the president is immune. So this kind of, the president doing things that may have tragic results, but they're doing them as part of their normal responsibilities in office, the president has always been immune. What the former president of the United States, Donald Trump, and what the Supreme Court is allowing is that this to be extended to former presidents who commit crimes that are not normally within the official acts of the President of the United States. And so that's where the problem lies. Okay? Now, this is another thing to keep in mind. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. So it's the states that are in control of setting the times, the places, and the manner of holding elections. Okay? Okay, so the senators and representatives shall receive a compensation for their services to be ascertained by law and paid out of the Treasury of the United States. They shall, in all cases except for treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses and in going to and returning from the same, and for any speech or debate in either house. They shall not be questioned in any other place. So this gives the protection that, again, whatever they say while serving in Congress on the floor of Congress is absolutely protected speech. Okay? So that is, again, to make sure that the members of the House and the members of the Senate feel free to debate and discuss any subject whatsoever. Now, again, there are certain, if they say something that is libelous or slanderous of an individual as a member of Congress on the floor of Congress, that is protected. But if they said that same thing outside of Congress in public, that they could be held accountable for that. They could be sued for slander. They could be sued for libel. Okay? But again, that the protection that this part of the Constitution provides only while they're serving in Congress and only while they are on the floor in the middle of debate over a particular issue. Okay, Article 1, Section 8 is the part of the Constitution that specifies the powers that Congress shall have. And so Congress shall have power to lay and collect taxes, duties, imposts, and excises. So let's think about this again. When we talked about the Articles of Confederation, we talked about how under the Articles of Confederation they prohibited Congress from levying taxes, and how that was one of the most fundamental powers that any government needs in order to function. The people who were the framers of the Articles were, for the most part, the same people who wrote the Constitution of the United States. And what shows they knew that is by virtue of the fact that when they're laying out the powers of Congress, the very first power that they give Congress is the power to levy and collect taxes. We're going to hit just some of the highlights. To borrow money on the credit of the United States, to regulate commerce with foreign nations and among the several states and with the Indian tribes. So this Clause 3 gives Congress the power over interstate commerce. Okay? State governments already had and still have power over intrastate commerce. This gave Congress, the Congress under the Constitution, the power to handle trade with foreign nations, trade between the different states, and trade with Native Americans. Clause 7, Congress has the power to establish post offices and post roads. So again, something that has always been considered a central responsibility of the government is to make it possible for mail to be delivered. And in order for mail to be delivered, we have to have post offices and roads where the postal carriers could get from one place to another. The reason this is something to pay attention to now is there is an effort to get rid of the Postal Service, the United States Postal Service. The idea is to put it in the hands of private industry. In other words, to allow for FedEx and UPS, which are for-profit entities, to handle the mail. And the problem with that is that it's if mail delivery is turned into a for-profit industry, well then the nature of for-profit industry is to cut costs. And so that's when you're going to start seeing some serious issues affecting mail service. That if you live in remote areas, you're going to have to probably pay more to have your mail delivered. Okay? And so this is, again, something that should be paid attention to. Congress shall have the power to declare war, grant letters of marque and reprisal. Letters of marque and reprisal, these are things that go back to an earlier time in history when you didn't have standing military forces like we have today. Today we have a standing army, we have a standing Marine Corps, we have a standing Air Force, a standing Navy. Okay? And so before you had that, Congress could give a privately owned ship a letter of marque. And that letter of marque would give that ship owner the authority to use their ship for military purposes. So in other words, they could intercept an enemy ship and take its cargo. And they would have protection of international law because Congress had issued them a letter of marque. You don't have that today. That kind of thing is not necessary. And then Congress shall make the rules concerning captures on land and water. Congress shall have the power to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years, to provide and maintain a navy. And the very last of the powers granted Congress is among the most significant. You may have been introduced to this part of the Constitution as the necessary and proper clause. It may have been introduced to you as the elastic clause. But what it simply says is that Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Now, this wording of Clause 18 was a major controversy when the Constitution was being debated and discussed by the state governments. And a big part of that controversy was because of the use of words like necessary and proper. Necessary and proper are words that do not have established definitions. So in other words, words like necessary, words like proper mean different things to different people. Okay? So what may be necessary for me may not be necessary for you. What may be necessary for you may not be necessary for somebody else. So you could have as many different meanings of necessary as there are people in the room. And let's not even talk about what's proper. And so the people who are reading this and debating it for the very first time, they had a real problem with this kind of vague language. And this will, again, when this goes outside the convention and is debated in the states, and then the states take a vote as to whether or not they're going to ratify the Constitution. This actually forced one final compromise that we'll talk about later, and that compromise resulted in the Bill of Rights. So we'll talk about this some more later. Now here, Clause 1 under Section 9 is the part that guaranteed the protection of the slave trade until January 1st, 1808. So the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808. But a tax or duty may be imposed on such importation not exceeding $10 for each person. Clause 2 is another issue that is extremely relevant for us today. The privilege of the writ of habeas corpus shall not be suspended unless, as in cases of rebellion or invasion, the public safety may require it. Now, the writ of habeas corpus is one of our most fundamental legal protections. But again, those protections are privileges, not rights. And as you may have learned already, I hope you have, the basic difference between a privilege and a right is that a privilege can be denied. A privilege can be taken away. Rights cannot be taken away. Rights cannot be denied. Okay? Now, the writ of habeas corpus is actually a collection of things, all wrapped together. And it's one of the things that makes the United States a unique country in comparison to most other countries in the world. In a good way. In this country, in the United States, no one can be arrested unless they can first be charged with a specific crime. Okay? So in other words, before they can arrest you, they have to be able to go through the U.S. law code. They have to be able to specify which specific law in the U.S. law code you have violated. Now, you can be detained but not arrested. Okay? Because sometimes it takes time to get information. So you may be detained on suspicion of murder. But if they can't find the evidence to actually charge you with murder, they have to let you go. Okay? And that's part of the writ of habeas corpus. And the other part of the writ of habeas corpus is that it means that once you are arrested, you have to be brought before a judge within a reasonable length of time, which has been interpreted to be 24 to 48 hours. You have to be brought before a judge where then you will be asked to plead guilty, not guilty, or no contest. Okay? So, if you plead guilty, well then the judge can pass sentence right then. Okay? So people may plead guilty right then if the penalty will be more than likely a fine. So the judge will say, okay, I plead guilty, and the judge says, okay, pay $100 fine on the way out. And then you're free. You've paid your punishment for the crime. Crimes that are more serious in nature will almost always they'll plead not guilty because that's the way to get a trial. So if you plead not guilty, the judge will schedule a trial date. And then depending on the nature of the crime, you will either be released with the promise that you will come back on the day your trial is scheduled to begin. But if there is any reason the judge may have that may lead them to think you will flee the jurisdiction of the court, then they will keep you in prison. They'll put you in jail until the day your trial date rolls around. So that way they can guarantee you'll be at the trial. Okay? So that is all part of the writ of habeas corpus. And we all have these protections. All persons have these protections as long as the writ of habeas corpus hasn't been suspended. Now, the only cases where the Constitution allows it to be suspended is, again, in cases of rebellion or invasion. And even then, only if the public safety may require it. What makes this worthy of our attention today is that Congress has suspended the writ of habeas corpus. And I'm willing to bet that there are a vast majority of people who do not even know this. Which may make some of you think I'm the one who's crazy. Well, I'm not. Congress suspended it in the immediate aftermath of 9/11. What happened is the United States went into Afghanistan in the immediate aftermath of 9/11 and began to arrest people. And once they were arrested by U.S. military, that put them in the jurisdiction of the United States, which meant before they could be arrested, they had to be charged with a specific crime. But that standard could not be met when they were arresting people in Afghanistan. And so the only way Congress could allow for those people in Afghanistan to be arrested is to suspend the writ of habeas corpus. And that allowed for the military to arrest whoever they wanted. Now, when the writ of habeas corpus is suspended, you can have people arrested without charge. You can have people arrested without bringing them before a judge. So you could actually then keep under the suspension of the writ of habeas corpus, you can have somebody put in prison for years without ever being charged with a crime, without ever being brought before a judge to plead not guilty, never having a trial. That's what can happen when the writ of habeas corpus is suspended. And what tells us the writ of habeas corpus is suspended is by virtue of the existence of the detention center at Guantanamo Bay. The few prisoners who are still there have been in prison now for more than 20 years, and they've never been charged with a single crime. They've never been allowed to plead guilty, not guilty, or no contest, and they have been imprisoned for that time. And the problem with something like the writ of habeas corpus, you can't suspend it for some and not others. Presidents have walked a fine line. You can go back, for example, Barack Obama, as a constitutional scholar, he was very much concerned about this. And if you go back and look at the history of President Obama's first term, one of his major commitments was to close Guantanamo Bay. Because the only way to restore the writ of habeas corpus would then be to put those prisoners in Guantanamo Bay under its protections as well. Which meant if we were going to keep them as detainees, we had to be able to charge them with a specific crime. And if we couldn't, we would have to let them go. But President Obama faced too much political pressure, and he had to give up on it. So in his statements on this that you find in the archives, is that he says this suspension does not apply to U.S. citizens. Nothing requires a president to say that. President Obama, however, made the effort. But with the suspension of the writ of habeas corpus in place, there could be a future precedent that doesn't make those kinds of guarantees. And this is when people may begin to find out that the writ of habeas corpus has been suspended. And if that's the case, then by that time, it's already too late. That's why it's imperative we shut down Guantanamo Bay. I mean, these guys have been there in prison for 20 years. It's time. Either charge them with a specific crime or let them go and restore the writ of habeas corpus for all of us. You may have actually come into contact with this, and I'd be curious to hear from some of you if you have. You may have heard people identified on the news, for example, as a person of interest, where you're watching the news and someone is their pictures put up on the screen, and you hear the news announcer say, the police are looking for this person as a person of interest. If you have any information as to their location, please contact your local police. A person of interest is somebody who they suspect of committing a crime, but they don't have the evidence to charge them for committing that crime. And if they bring that person into custody, they can actually hold that person without charges until they find the evidence to charge them with the specific crime. And that, again, is turning our whole legal process upside down. That's when a person is being presumed guilty instead of being presumed innocent. Now, again, we're still, in terms of history, we're still early on in this. It's been just over 20 years. And there are still far too many of us who are alive who remember the way it was before 9/11. But eventually, among those who remember the way things were before 9/11, who, if we saw the authorities beginning to arrest citizens of the United States, we'd be out there screaming bloody murder. Among those people would be people like me. But at some point, I'm going to die. And so will the rest of us who remember the way it was before 9/11. And by that time, you will have an entire generation of Americans who have been born and raised under the suspension of the writ of habeas corpus. And again, there are politicians who want to be able to do this, who want to keep this going. Not necessarily because they're targeting citizens, but when you hear talk about a massive roundup of undocumented immigrants, they too are protected by the writ of habeas corpus. Again, this is when the writ of habeas corpus is in place. It extends to all persons who are within the jurisdiction of the United States. And if you're an undocumented immigrant within the jurisdiction of the United States, you're still a person. So the only way you can have this massive roundup of undocumented immigrants is if the writ of habeas corpus has been suspended. And the more we tolerate it for people on the fringe of our society, we establish it as a precedent that may then be where it is turned against all of us. That, again, is why this is only as good as we are. And again, as horrible as 9/11 was, it was not a rebellion. A rebellion is like the Civil War. It wells up from within. And it was not an invasion. Yes, it was an attack, but an attack is not an invasion. An invasion is when you attack and you stay and you continue the attack. Okay? So like the D-Day invasion, British and American troops invade northwestern France, and we continue to fight the Germans in France until the war is over. That's an invasion. Again, as horrible as 9/11 was, it was not a rebellion or an invasion. But because so many Americans were scared and horrified by what happened, we didn't quibble over the technical meaning of words. And so, the surest way to know that the writ of habeas corpus has been restored is to shut Guantanamo Bay down. Bin Laden is dead. We really need to begin to ask, why should Guantanamo Bay still exist? Anyway, ex post facto laws are important, and I'll talk about those later. Clause 8. Section 9, Clause 8. No title of nobility shall be granted by the United States and no person holding any office of profit or trust under them, without the consent of Congress, except of any present emolument, office, or title, of any kind whatever, from any king, prince, or foreign state. Okay? So we wanted to make sure that there was not a nobility in this country. So we specifically prohibit the United States from extending titles of nobility on Americans, and even foreign governments cannot bestow a title or nobility on an American without permission. So, for example, there are groups of nobility, noble titles in countries like England that are honorific. Okay? In other words, they don't give you any specific authority. They don't give you a salary. They don't give you a any other kind. What they give you is an honor. Okay, so an American can be given one of those honorific titles by the British, but only on permission of Congress. And again, if it's one of the honorific titles, Congress, yeah, that's fine. Go ahead. Okay. Now, and no person holding any office of profit or trust under them shall, without consent of the Congress, accept of any present emolument, office or title of any kind from any king or prince or foreign state. So any present or gift, emolument. This is a word few people know, but it's an important word to understand. Okay? An emolument. Well, let me put it this way. There are things that have a universal, that are recognized universally for their value. And for example, we all recognize the value of gold and jewels and silver and things like that. Okay? And so then, an emolument means any object of value. And what makes the word emolument important to understand is that it may not be of value to you, but it may be something I find valuable. So, you might be, for example, a collector of comic books. I'm not. So, the first edition of Action Comics, the first issue of Action Comics where Superman is introduced, that may be of value to you, but not to me. Now, to me, there's a 15-volume set of books focusing on the British Empire in North America before the War for Independence. 15 volumes. I want that. The cheapest price I've seen for it is $2,000. And if I had $2,000, I'd pay it. Yeah. That's something I find valuable. But it's a safe bet. No one else does. Okay? So, if any of you have a spare $2,000 lying around, just kidding. So this covers everything. Because there are a lot of things that different people for different reasons find valuable. And so it's not like money. We all would find money valuable. Okay? So again, this was brought up during the first Trump administration because the argument was made by virtue of the fact that he continued to control and receive profits from his hotel in Washington, D.C. He was receiving an emolument. Because as the owner of the hotel, if you rented rooms in that hotel, then Donald Trump, as president, was receiving money. He was receiving something of value. But only, again, he would be getting that money from people renting rooms in that hotel. So no one else outside of the ownership of that hotel received any benefit. That is what would make it an emolument. So, again, this is something that we need to discuss once again because we now have, for the first time in the whole history of the United States, a president who was brazen enough to go against it. No one had ever done that. No one had ever done that before. So, and there's even, to make it clear how seriously the framers took this, they even come back to emoluments in Article 2 when they talk about the presidency, and we'll see that shortly. Okay. Actually, I think I'm going to end this video at this point, and when we come back, we'll start with Article 2.